Federal agents searched a county elections office in Georgia, looking for the original paper ballots cast in the 2020 presidential election. That is the core, verified fact here, and it's worth sitting with because it raises a question that has followed American politics for nearly 6 years. What happens to the evidence of an election once the counting is done, and who gets to look at it again? Multiple news reports say the office searched was the Fulton County Elections Office in Georgia, one of the most scrutinized single jurisdictions in the country since the 2020 vote. The reports tie the search to an investigation into ballots cast that year. Federal authorities haven't detailed, at least not publicly and not yet, the full scope of what they're investigating, and that gap between what's confirmed and what isn't is exactly where this story lives. We're going to walk through this carefully and tell you only what is actually known. Not what's rumored, not what commentators on either side are speculating about online, but what's been reported and what's a matter of public record. By the end, you'll understand what Fulton County's elections office does, why federal ballot retention rules exist, why this county has been a flashpoint since November 2020, and what would legally have to happen next for any of this to turn into criminal charges against anyone. We'll also keep saying, plainly, what we don't know, because in a story like this, the gaps matter as much as the confirmed facts. Start with what's actually reported. FBI agents conducted a search of the Fulton County Elections Office. Reporting describes the purpose as an effort to locate original paper ballots from the 2020 presidential election. Democratic officials in Georgia, along with voting rights advocates, have publicly criticized the search, calling it alarming, and some have framed it as part of a broader pattern of federal scrutiny aimed at the 2020 results. Federal authorities haven't laid out, publicly, what specific legal theory or allegation is driving this. That distinction matters. A search is not a charge. It's not an indictment. It's a step taken because investigators believe there's probable cause that evidence relevant to some inquiry exists at a particular location. What that inquiry actually concerns, in terms of a named statute or a named target, hasn't been confirmed publicly as of this reporting. Here's what surprises us about this story. It isn't the raid itself. Federal agents searching a government office isn't, on its own, extraordinary. What's surprising is how little has actually been confirmed even as the story generates national attention. There's no confirmed accusation against a named individual, no confirmed charge, no confirmed statement from the Department of Justice laying out a theory of the case. What exists, publicly, is a search, a location, a general subject matter, and a wave of reaction. That's the entire confirmed record right now. Everything else circulating is inference, speculation, or political framing stacked on a fairly narrow set of facts. One obstacle in telling this story honestly is the sheer amount of noise around it. Fulton County has been the subject of lawsuits, audits, recounts, and partisan claims since November 2020, and separating what's newly reported here from years of accumulated controversy takes real care. We handled that the only way you can, tracking every claim back to whether it belongs to this specific search, this specific reporting, or to the broader, multi-year history of Fulton County election litigation. Anything we couldn't tie directly to this event, we're treating as background and labeling it that way, not folding it into the current story as if it were new evidence. So, some background, clearly separated from the current reporting. Fulton County is Georgia's most populous county and includes most of Atlanta. In the 2020 presidential election, Georgia was decided by a margin of under 12,000 votes statewide, one of the closest states in the country, which put every county's process, especially the largest one, under a microscope. Since then, Fulton County's election administration has been the subject of multiple state-ordered audits, at least one hand recount of the presidential race under Georgia law, litigation from multiple parties challenging aspects of the vote, and ongoing public records disputes over access to ballot images and related materials. None of that is new. It's well-documented public history, and it's the backdrop against which any new federal action involving this office will be read by nearly everyone, regardless of politics. Here's a legal detail that doesn't get much attention outside election law circles, and it's where this actually gets interesting. Federal law requires election officials to preserve and retain records related to federal elections, including ballots, for 22 months after the election. That requirement exists so that if a dispute or investigation arises, the underlying paper record isn't gone. For the 2020 election, that 22-month window closed years ago. So if federal investigators are searching for the original ballots now, in an investigation that's apparently still active, the question of what's been retained, by whom, and under what state-level retention schedule becomes central to understanding what this search was actually looking for and why now. That detail is context, not an accusation against anyone. We're not saying ballots are missing. We're not saying anyone destroyed anything. We're saying the retention and custody question is exactly the kind of thing a federal investigation into election records would need to resolve, and it helps explain, in general terms, why an original paper ballot might become the object of a federal search years after an election concluded. The search happened. The reaction from Georgia Democratic officials and voting rights groups was immediate and pointed. But the actual legal target of the investigation, the specific statute being examined, and whether any individual is currently a named subject, remain undisclosed. That's where the confirmed record stops. What happens next depends on decisions inside the Department of Justice that haven't been made public. A word on how a case like this would actually have to proceed if it were heading toward charges, because public conversation tends to skip this step. A search warrant requires a federal judge to have found probable cause based on a sworn affidavit from an investigator. That affidavit is typically sealed, at least initially, which is part of why the public doesn't yet know the specific legal theory here. If the investigation eventually produces charges against a specific person, that person would be formally accused, not convicted, and under the American legal system, they're presumed innocent unless and until a court finds otherwise. We want to be precise about that, because language matters here. Words like accused, alleged, and charged aren't softened language. They're legally accurate language, and using anything stronger before an actual charge exists would be inaccurate, not just cautious. Another obstacle is a structural one. Sealed search warrant affidavits mean outside observers, including journalists, are working with a genuinely incomplete picture by design. That's not a failure of reporting. It's how federal investigations work in their early stages, specifically to protect the integrity of ongoing evidence gathering and avoid tipping off subjects before agents have secured what they're looking for. The trade-off is that the public, including us, right now, is left interpreting a search location and a general subject area without the legal reasoning a judge already reviewed. That's frustrating if you want full clarity immediately, but it's also the design of the system, and it will likely resolve, one way or another, as this investigation either moves toward charges or closes without any. Here's the take that will probably draw pushback either way. We think both extremes in the public reaction are getting ahead of the actual record. Framing this as proof of a stolen or fraudulent election overstates what a search warrant confirms, which is that investigators believed there was probable cause to look somewhere. Not that any fraud has been established, but framing this as unwarranted political harassment of a county elections office also overstates what's confirmed, because dismissing a properly authorized federal search, approved by a judge, as inherently baseless requires ignoring the legal threshold agents had to meet to get a warrant in the first place. Both readings skip past the same gap. Nobody outside the investigation currently knows what's actually in that affidavit. So where does that leave the reactions we've seen so far? Georgia Democratic officials have publicly criticized the search as alarming. Voting rights advocates have echoed that concern, tying it to a broader worry about federal scrutiny of the 2020 results. Those are real, on-the-record reactions, and they matter as part of the story. But they're reactions to the search, not new factual disclosures about what investigators found or didn't find inside that office. Hold that distinction in mind as more coverage develops, because public reaction gets reported and re-reported until it starts to feel like confirmation of something about the underlying investigation, when really it just shows how officials and advocacy groups are choosing to respond. Does a properly authorized federal search of an election office, on its own, tell us anything meaningful about what investigators have actually found? Or is it simply too early to draw a conclusion? That's a genuine question, worth sitting with before you form a firm opinion on a story that is, by every account we can verify, still in its early stages. There's a line that tends to get lost in coverage like this. The Department of Justice has an entire section, the Public Integrity section, dedicated specifically to overseeing federal election crime matters and prosecutions involving public officials. Investigations opened by that section, or in coordination with it, follow the same evidentiary standards as any other federal criminal investigation. They require evidence sufficient to meet a probable cause threshold for a warrant, and eventually, if charges are filed, evidence sufficient to convince a grand jury to indict, and ultimately, a jury beyond a reasonable doubt to convict. None of those later stages have been reached here, as far as anything currently confirmed shows. We mention that structure not because we know it applies in this specific case, but because understanding the actual legal ladder shows just how far a search sits from a conviction and how much has to happen in open court before anyone should treat an allegation as settled fact. A third obstacle, frankly, is time. Investigations like this can take months or years to resolve, and the public record often expands in small, disconnected pieces. A court filing here, a subpoena reported there, an official's statement somewhere else. Anyone following this story in real time has to be willing to update their understanding repeatedly as those pieces surface, rather than locking in a conclusion off the first headline. We don't know how long this particular investigation will take to produce a public resolution, if it produces one at all. Some federal inquiries close quietly, without charges and without a public statement explaining why. We cut a fair amount of surrounding political commentary out of this video on purpose, because most of it doesn't add a confirmed fact, it just adds volume. If you want us to cover how this develops as new filings or statements become public, tell us in the comments. This story is genuinely likely to keep producing new, checkable information over the coming weeks. So here's where things actually stand, as plainly as we can put it. Federal agents searched the Fulton County, Georgia Elections Office. The search has been reported as connected to an investigation involving original 2020 presidential ballots. Georgia Democratic officials and voting rights advocates have criticized the action publicly. No individual has been named as a defendant in this matter as far as confirmed reporting shows. No charges have been filed in connection with this specific search as far as confirmed reporting shows. And federal authorities haven't detailed the full scope of the underlying investigation. Everyone named or referenced in connection with this matter is entitled to the presumption of innocence, and nothing in this video should be read as an accusation against any specific person, because no specific person has been publicly and confirmedly charged with anything in relation to this search. What we genuinely don't know yet, and want to be direct about, the specific statute or legal theory investigators are pursuing, whether any ballots were actually located or seized during the search, whether any individual is currently a named subject of the broader investigation, and what prompted the timing of this action now, years after the 2020 election. Those are open questions, not facts we're choosing to withhold, and anyone telling you they have confirmed answers to all of them right now is very likely getting ahead of the actual public record. If you want to follow this directly rather than through secondhand summaries, the most reliable path is the primary sources themselves: FBI national press releases, Department of Justice press releases, and public court filings if and when any are unsealed. We'll link what's currently available, and we'll come back to this story when there's genuinely new, confirmed information to report, not just new reaction to the same search.